Hello, I'm Doug Muzzio. This is City Talk. It's 225 years old this year. It's the oldest in the country, older than the Supreme Court. It is the largest and busiest in the country. It is a crucible of truth and justice. It's the U.S. District Court for the Southern District of New York. Its signature trials and towering jurists are the subject of James Zirin's Mother Court, Tales of Cases That Mattered in America's Trial Court. Jim is the host of CUNY TV's Conversations in the Digital Age. He is a major litigator and has served as Assistant U.S. Attorney for the Southern District in the Criminal Division under the legendary Robert Morgenthau. He is a Fellow of the American College of Trial Lawyers, on the editorial board of the New York Law Journal, and a member of the Council on Foreign Relations. Welcome, Jim.
Well, thank you. I'm glad to be here, really glad to be here.
Fascinating stuff and very, very nice reviews. You love the Southern District Court. You love it.
I fell in love with it as a college student. And what I did was, on vacations, I had nothing better to do, so I'd roam around the courthouse looking for trials. And
Great fun.
Great fun. And I'd wander into criminal trials because they were easier for me to understand then. And I saw some great ones. I saw some terrific trials.
So you got the bug by actually wandering around the courthouse.
Yes, and I loved the drama of the courtroom, and I knew that was for me.
So you were convinced early on. Okay, why is the district court called the Mother Court?
No one knows for sure, but there are probably two reasons. One is it's the oldest court, as you said, in the United States. It was organized in 1789 under the First Judiciary Act. It's 2 weeks older than the United States Supreme Court, which originally met here in New York.
Right. Well, we were the first capital.
We were the first capital. And it is also called the Mother Court because it won preeminence really in the 20th century with the appointment of two cousins to the bench. One was Learned Hand and the other was Augustus Hand, who later went up to the Court of Appeals. And they began writing these decisions which were transforming in terms of our law and transforming in terms of our society as it emerged in that period of time.
Okay. Give us some background on the court structure, because you really have two parallel structures. You have the federal court system, and then you have 50 state court systems. Let's start with what you focus on, and that's the federal court system. How is it organized?
Well, we have as you said, we have a two-sovereignty system, so that we have 50 state courts in each of the states, and then we also have a federal system, which was established in the Constitution, because they said the judicial power shall be in the one Supreme Court, and such inferior courts as Congress shall ordain and establish, and they established.
And that's all they said, and we've got this rather elaborate structure.
So, I mean, even with the Supreme Court, the Constitution didn't say how many justices there were to be.
And that's changed over time,
it has.
legislatively.
Yes, it has. Congress changed that. Originally there were less, then there were more, then they went back to 9 until Roosevelt tried to pack the court
to 15
in 1931.
Yeah. So what do the various levels do? Essentially, there are 3 levels. What do each of the courts do, and where is the place of the Mother Court in this system?
Well, the Mother Court, the Southern District, and all the district courts are courts of original jurisdiction. That's where the case is first brought. And then there is a trial, unless there's some sort of disposition. If someone doesn't like the result, they go to the next level, which is the United States Court of Appeals. In the case of New York, it's for the Second Circuit.
And there are how many? 9 circuits?
Well, there are actually 10.
10.
And then there's a federal circuit for patent cases. But the Court of Appeals in the Second Circuit will review the record in the district court and decide whether or not there's been an error of law.
Okay.
The facts are tried
in the lower court.
In the lower court.
Okay.
And they're determined either by a jury or by a judge sitting without a jury.
Okay.
Depending on the case.
Okay, let's look at the book itself. You describe it on page 303 as history enhanced by intimacy. You were there in the 1960s, as I said, under Morgenthau, who wrote the introduction to the book. Talk about that office, the feel of the office. What do you viscerally remember about entering the office and actually working through it?
Well, what I remember was that Bob Morgenthau was a quintessential public servant. It was in his DNA, and it was contagious. And his grandfather had been Wilson's ambassador to Turkey. His father had been the Secretary of the Treasury under Franklin Delano Roosevelt. He himself had served in the Pacific. He was floating around for 8 hours before he was rescued.
Had his boat shot out from under him.
The boat was shot out from under him. Many of his the people on the boat were killed, so he had that sense of dedication to the country, and we had also a great sense of independence, because he believed the United States Attorney's Office should be independent of the Justice Department in Washington. Now, administratively, we were subject to the Attorney General. We got our budget from Washington. We had all sorts of controls that were exercised by Washington. But when it came to deciding who would be prosecuted and who wouldn't be prosecuted, Morgenthau claimed he was independent of Washington.
And he was also expert in getting around the Justice Department in terms of who he contacted at Justice. I mean, there was a real strategist there.
Oh, yes. Well, he was really the best bureaucratic infighter that I ever saw in action. So if he wanted to indict the water commissioner, and he knew that if he talked to the right people in Washington, it might take several months before he got an approval.
Who were the wrong people?
Who were the wrong people.
Go ahead.
He would call some very low-level person in Washington and say, hi, it's Bob Morgenthau, and things are great in New York. The sun is shining. Things are terrific. And by the way, I'm going to indict the water commissioner. And the guy was so overawed that he got a call from Bob Morgenthau. He wouldn't say anything, or he'd say, oh, sure. And isn't that great news? Thank you for calling. And he'd say, then he'd turn around with a big smile and he'd say, look, we just got approval to indict the water commissioner. And all of his assistants would stand around and smile at each other. They
First
couldn't believe
case.
it. Couldn't believe it.
Your first case, working under Morgenthau.
My first case was a jury trial before the iconic Judge Edward Weinfeld. And
one of your heroes.
He was one of my heroes. Now, I first became acquainted with Edward Weinfeld when I was a college student roaming the halls of the courthouse. And he was trying the case against a Supreme Court judge in Brooklyn, J. Vincent Keogh.
Very famous corruption case.
Very famous corruption case. And the U.S. attorney, actually, in the Eastern District, Elliot Kahaner. And there was a third defendant who was Anthony Tony Ducks Corallo, who was a mobster.
Yes.
And this case had romance and it had drama. And I remember that Weinfeld ran the courtroom with an iron hand. He would take the bench at 10 o'clock sharp. There was a Catholic church adjacent to the courthouse, St. Andrew's Roman Catholic Church.
Sure.
And there were bells that pealed the hour. And at 10 o'clock, when it pealed the hour of 10, there'd be a knock on the door and Weinfeld would take the bench.
Come on.
Woe betide the lawyer who was 3 minutes late because he was stuck in the elevator.
Oh, God.
He was a no-nonsense judge. And when he spoke to the jury, there was a very special quality to it. It was like Heifetz playing a Stradivarius. He was at one with his instrument. And he was a New York judge. He came from the Lower East Side. He
Yes.
talked in their language and in their accents. And he was really the 13th juror in the box. Well, I saw him try this case, and that's when I really decided I wanted to be a trial lawyer. And lo and behold, I'm appointed an assistant United States attorney, and I thought I'd get some instruction, but somebody put a file on my desk and said, you have a trial before Weinfeld. And I couldn't believe it. It was a jury trial. Well, you go out with a more experienced assistant,
right.
But it was a baptism in fire. And at the end of that trial, my shirt was wringing wet. And it was unbelievable how he ran the thing and how he put me through my paces. We got a conviction.
I was going to say, what was the disposition?
We got a conviction, and that was my first jury trial, and I was off and running.
Morgenthau's only there, you're only there 3 years. Morgenthau was appointed when? In early 60s by Kennedy?
He was appointed in 61 by Kennedy.
By Kennedy. Another person who had his boat shot out from under him.
Another person from the Navy, from the Pacific. But Morgenthau was there. He took a leave of absence, in effect. He resigned so he could run for governor. It was unsuccessful.
Right.
He came back, and everyone knew he was going to come back. And he appointed me in 1967. In 1970, he was dismissed by Nixon because he was a Democrat. Nixon wanted a Republican. And Javits, who was the senator from New York, decided he also ought to have a Republican because the president can have anyone he wants.
Sure.
So Morgenthau was dismissed, and emotionally, I just felt I didn't want to continue there because the man who had appointed me and the man whom I absolutely adored was no longer going to be in office. I couldn't believe I'd have the same independence and the same freedom. And my old law firm called me, and they'd read about this. It was front page news everywhere. They said, if you're thinking about coming back, we'd love to have you. And so I left. And
then you became a litigator, and you argued before some of the very people that, in a sense, you served as an officer of the court.
Well, I became a litigator, and I represented mostly defendants in civil cases, sometimes plaintiffs. I appeared before some of the same judges, and there were new judges always being appointed. And I was trying cases and using the skills that I'd garnered as an assistant U.S. attorney. So I never forgot my beginnings, as it were.
Okay. You divide the book into several sections. I mean, the book is interesting insofar as it's both a history of the mother court, it's also a history of the judiciary, but it's also a memoir of your interaction with the court. And you divide the cases that you are most attracted to into the us versus, or U.S. versus. So let's look at the U.S. versus, looking at the various trials. Let's talk about U.S. versus the mob. I mean, the mother court has been at the center of the trial and, in fact, the degradation of the American organized crime, the mafia, if you will. Well, talk about those cases.
The Morgenthau office was very active in prosecuting organized crime cases, and I was personally involved in some of them. First case was really the Appalachian case, which is a very interesting conspiracy case.
Great case, go ahead.
100 members of the mob from all over the country descended upon a farmhouse in Susquehanna County in Appalachian, New York, for a meeting. And no one in the government knew what the purpose of the meeting was. But they knew that attending the meeting were the rogues gallery of the American underworld. And so a joint state and federal police task force raided the meeting. And the mobsters ran out into the woods and throwing $100 bills behind them because they didn't want to be caught with all this black money. And they're wearing patent leather shoes. They're all in the mud. They have these custom-made suits, and they're trying to get as far away from the house as possible. They arrested about 20 of them whom they brought to trial. And they were asked, what were they doing there? And each one, with the exception of one, each one answered, we were there visiting Mr. Barbera, who owned the house, because he was ailing, and we wanted to find out how he was doing.
Perfectly reasonable.
All over the country. One of them said he was there to deliver fish, which is also perfectly reasonable. So the government went to trial, and they were convicted for conspiring to tell the same story, which was false, as to why they attended the meeting. But the government never proved that they were doing anything other than visiting Mr. Barbera. This meeting was later fictionalized, of course, in The Godfather and The Sopranos.
Absolutely.
So, and everyone knows that it was really held in order to divide power between Genovese and Costello, who were warring
mob war,
of the mob. And in fact, Anastasia, who was Costello's henchman, was rubbed out in a barbershop in Midtown Manhattan.
With a warm towel over his face.
The blood-splattered barber's chair is now in the Mob Museum in Los Angeles.
Hey, come on. I mean, where else would you?
How's that for a footnote to history?
That's good.
And then there was a story also when Costello was going home one night. This is before the meeting. And he lived in the Majestic on Central Park West, this Art Deco building. And he's entering the building, And one of Genevieve's henchmen, a guy named Chin Gigante, walks up to him.
Crazy? But is this crazy? This is the crazy. Okay.
Pulls a gun. Crazy Chin Gigante pulls a gun, and he says, "This one's for you, Frank." And Costello turns his head, and the bullet grazes his ear, and he isn't killed. So they ask Costello, the police ask Costello, you know, who pulled the trigger? Who was the trigger man? Do you know who assaulted you? And Costello said, no, I don't know who it was. So what they really did, were trying to do at the Appalachian meeting, was to demote Costello so he would only have a small section of the country and Genovese would have the rest.
Talk about the pizza connection.
Now,
longest trial.
Longest trial in history is a masterpiece of trial management by Judge Pierre Laval. You had well, as frequently happens in these cases, one of the defendants was murdered before the trial began. Another one was murdered during the trial.
You can't make this stuff up.
Can't make this stuff up. And you had, I think, 20 defendants, 20-odd defendants who went to trial. It
was huge.
And, of course, the name of the game was to prevent evidence that came in against A defendant to be binding or be used against defendant B. So it was a masterpiece of trial management so that Laval was able to sort it out and so that the jury was able to consider the guilt of each defendant, and Laval was able to consider the guilt of each defendant apart from the conspiracy, and then the whole case went to the jury. And I think they were all convicted, and then one was reversed on appeal. So it was a very successful prosecution for the office of Rudy Giuliani, who was the U.S. attorney at the time.
Yep. Talk about conspiracy cases, though. It seems to me, at least by inference, you're not necessarily a big fan of conspiracy cases.
Well, when I was a prosecutor, I was a big fan. Learned hand called Conspiracy the darling of the prosecutor's nursery. And the reason it is you have the chance to...
You don't need evidence. It's all
well, you do need evidence, but you bring
them
in... Well, some of it can be hearsay. That's the real thing.
God.
But you can bring them all into the same courtroom. And while the judge will fall all over himself trying to prevent a spillover effect, as I said with Judge Laval, the fact is the jury thinks that birds of a feather flock together and they're all there in the same place. And they're caught up in this dragnet. And the other thing is that there is an exception to the hearsay rule. So if there are declarations, hearsay declarations, in furtherance of the conspiracy, those come in against all the defendants.
Isn't that dangerous, though? I mean, in the hands of a prosecutor. I mean, prosecutors can be your friend, but prosecutors are also dangerous folks.
Well, yes, and that's why we have so many checks and balances on the power of the prosecutor, which are built into the system. And the prosecutor has to get an indictment before a grand jury. He has to present the case before a judge. He has to prove the allegations of the indictment, which is the blueprint of the prosecution, beyond a reasonable doubt. The jury verdict must be unanimous, and then, of course, it's subject to judicial scrutiny to be sure that the evidence is sufficient. And, of course, one of the things they scrutinize very carefully are conspiracy prosecutions to make sure that someone isn't just swept into the dragnet because they were present.
Okay. Another U.S. was the U.S. versus sex. And you go through a whole series of cases that were litigated before the mother court. Talk about the general thrust of these cases and their impact.
The first interesting case was the Ulysses case in the mid-30s. And there, Grove Press, which had published Ulysses, and I guess Bennett Cerf, who was, I guess, Random House had also published it. And the lawyer was Morris Ernst, who was a great civil liberties lawyer, and they wanted a test case. So the government seized the book Ulysses, which was a book of about 900 pages.
It was a doorstopper. I've read it, and not understood it, but I've read it.
It had one dirty chapter. And
it wasn't that good.
Judge Woolsey wasn't that good, and certainly by today's standards, it was nothing.
Tame.
It was very tame. Judge Woolsey established the proposition that if it's a dirty book, you don't just read the dirty part, you read the whole book in context to decide whether the book is dirty. And he wrote really the first seminal opinion in the pornography area. And he held that because of freedom of speech, that the book could be published and the book could be distributed in the United States.
Yeah, and there were other cases that you allude to, the I Am Curious Yellow, Deep Throat, etc., all in retrospect are extraordinarily tame.
Particularly with the internet. And we don't have pornography prosecutions except in the area of child pornography. We don't have pornography prosecutions at all anymore. There's nothing that the government can do about it.
Because it's ubiquitous. Okay. Talk about the U.S. versus the press and mainly the great Pentagon Papers case.
Well, that was, of course, was before Judge Murray Gerfon in the 70s. And Nixon and Kissinger decided they didn't want this report to come out, which really reflected adversely on the Johnson administration, which had conducted the Vietnam War. And the New York Times, the case was tried, there was a case brought against the Washington Post in Washington. And the judge there allowed them to publish. And the case was brought before Judge Gerfon. There were witnesses on this issue of national security, which Gerfon was quite familiar with because he had been in Army intelligence and the OSS in World War II. And he concluded that national security wasn't affected at all. A good deal of what's in the Pentagon Papers was in newspapers, magazines, periodicals that were available to the public. And the government claimed, well, just assembling them in one place was a national security issue. And, but Gerfon swept all that aside, and in ringing words, he said, the security of the nation is not at the ramparts, but it's in the freedom of our institutions. And he approved of it. He was reversed by the Court of Appeals for the Second Circuit, and then it went up to the Supreme Court. We were talking about the levels of appeal. Of course, the court of last resort is the Supreme Court, and they hear what they want to hear, while the Court of Appeals has to hear an appeal from a final judgment. And they went up to the Supreme Court, and the Supreme Court affirmed Gerfon, I think 6-3.
And then another group that I just want to briefly talk about, since it was sort of so central in sort of my period of growing up, was Us versus Us, the so-called Red Scare cases, the Rosenbergs, Hiss, and then you've got some rather harsh evaluation of the judge, Judge Kaufman, in the Rosenberg case. Talk about that case, since it's such a still argued case.
It still is argued, and it's amazing how it haunts, at least the execution, haunts the national consciousness, and it keeps coming up. I mean, Greenglass, who was the major witness against the Rosenbergs, died about 6 or 8 months ago. And there was a big article in the New York Times. I am very critical of the sentence in the Rosenberg case, as well as the conduct of Judge Kaufman during the trial.
Really unprofessional, as you lay it out in the book.
Well, he did engage in ex-parte communications with the prosecution, particularly as the sentence. The FBI didn't want a death sentence. There were many other people all over the world who didn't want a death sentence. And you look at the how other spies were, particularly atomic spies, were treated in the courts. I mean, Klaus Fuchs in England, I think, served 9 years. He may have been sentenced to 20 or 30 years, I don't remember. And Greenglass himself served 9.5 years. And he was an admitted spy and gave secrets to the Russians. Here, these two people were executed. It appears the evidence against Mrs. Rosenberg was perjured. It was manufactured. Roy Cohn, who was one of the prosecutors, had a hand in that.
Not one of your favorites. We won't go into him.
Not one of my favorites.
Not at all.
And Kaufman imposed the death penalty, probably because he thought he would curry favor with the Department of Justice by doing it. But what was interesting is that that case and that sentence was with him for the rest of his life. And the only thing he ever wanted was to be known as a judge who was a friend of the press. And he courted the press, and he wrote opinion after opinion upholding press freedoms. And he was hoping that in his obituary there'd be no reference to the Rosenberg case.
Wrong.
The headline in the New York Times was, Irving Kaufman dies, a judge who decided the Rosenberg case and sentenced them to death, and then dash friend of press freedoms.
Nice. So he got the secondary headline.
Yeah.
Okay, we don't have much time. Favorite judges, my favorite judge of your favorite judges is Thomas Murphy. Give us an anecdote or two from Murphy.
Well, he was unbelievable. Of course, he'd been the HIS prosecutor. He'd been the New York City police commissioner. He was a New York legendary figure because he had huge shoulders. His brother, which probably ran in his family because his brother was a relief pitcher on the New York Yankees, fireman Johnny Murphy.
Oh, okay.
You remember fireman Johnny
Yes.
Murphy? Yeah, and he played with Ruth and Gehrig. But Murphy had a marvelous sense of humor. And his courtroom was a very tight ship. He liked to say, "I'm the boss here." He had this deep basso profundo voice. And I remember there was one criminal arraignment before him where the defendant was a black Muslim. And Murphy inquired of him, as you do in an arraignment, "Do you have a lawyer?" And the defendant rose to his feet and said, "Your Honor, Allah is my counsel." And Murphy said, "Who represents you locally?"
I know.
That's
a great anecdote. We only have 30 seconds, and unfortunately, not enough time to answer this question. The court now, you say the court's losing business, that it's being adversely challenged by technology, plea bargaining, and sentence guidelines. Talk about, real briefly, the court now and what you see in the future.
Well, there are spectacular judges on the court now. Some of the recent appointments to the bench have been just fabulous. Supreme Court clerks and others, terrific backgrounds. I think the court is still handling cutting-edge issues. Decided the gay marriage case involving Edie Windsor, the Defense of Marriage Act. It was involved in the National Security Agency case, the NSA case, the surveillance case. And it also tried successfully at least 2 terrorism cases recently, which resulted in convictions.
But not the big one, and you'll have to come back to talk about the KSM case.
The big one. But I think because of technology and because of the tendency to plea bargain and to settle cases, you don't have the major trials, the dramatic trials that we used to have. So do I say it's worse? No, I don't say it's worse, but I do say it's different.
My thanks to Jim Zirin for the stroll through the U.S. court system and its mother court, a most fascinating place. Join me next week when we revisit the show we did with Terry Galway, author of Machine Made, Tammany Hall, and the Creation of Modern American Politics, here on CUNY TV. Thank you.
That was wonderful.
Thank you.
So much.
I'm Doug Muzzio. Let us know what you think about this show. You can reach us at CUNY.TV. When you get there, click on the bar that says Contact Us and send your email. Whatever it is. Thanks, no thanks, obnoxious, do it. Send it.